The United States Court of Appeals for the Fifth Circuit is now open, according to law. God save the United States and this honorable court.
Please be seated. Good afternoon, ladies and gentlemen. Welcome to the Fifth Circuit Court of Appeals. We have 3 cases to be submitted today on oral argument. We appreciate Judge Haynes coming down from Dallas, and we also very much appreciate the availability of all of the attorneys who will be arguing, and I appreciate the help of our local staff as well in filling in. And we will begin with United States versus Navarro-Jusino. Mr. O'Shea.
Good afternoon, Your Honors. May I proceed?
Please.
Thank you. Your Honors, this is a case that is not very complicated. As a public defender, I'm always aware and very conscientious of my clients' economic status and how they will be treated by the justice system. In this case, this is an economic crime where there was devastating consequences to a victim, as in most economic crimes of fraud, wire fraud, bank fraud, thefts. There was one victim in this case, and the case lasted about a year before it got to sentencing. And Mr. Navarro-Jusino, who was out on pretrial release, wanted to know about restitution, like most clients do, and how it would impact sentencing. And so when I talked to the government and I said, would it make a difference if we could pay this down? Mr. Gibson's response, rightfully so, according to case law and that's out there, is that no defendant should be able to buy his way out of a sentence. And that makes sense. And that's supported by the case law that goes way back to Justice Black when they start talking about economic impact and how it should impact someone's due process and whether or not the Equal Protection Clause is violated. And in this case, when we got to sentencing, we didn't pay in advance because it makes sense. You shouldn't be able to buy your way out. I represent an indigent defendant, so we came up with a plan. And his family and his wife came up with a plan. His wife was working on a real estate license, and we presented that plan to the court. And what the response was, the response of the court was, I don't believe he's going to pay this restitution back, and it's noted 3 times in the record. It's very clear. Based on all of the cases that I have heard, the 5,000 cases, only one person has paid back restitution. Therefore, I don't believe he's going to pay back restitution. Therefore, I'm going to give him an upward variance of 365% from the top of the guideline range. The government didn't ask for a variance upward. The government didn't ask for a departure upward. There was no indication in the pre-sentence report that there would be a departure upward or any variance upward. There was no aggravating circumstance to indicate ahead of time to be prepared for an upward departure. But nevertheless, there was a devastating impact to this victim, as in all cases, as in many cases. So the question has to be raised in fairness. In every case where there's restitution in front of this court, is this aggravating factor going to be the basis for an upward departure? Because this factor that only one person out of 5,000 cases in this court has made restitution, therefore we're going to speculate that this person, based on those averages, will not make restitution. Is the banker who defrauds a bank going to be held to that same standard? Is someone who sells securities on the New York Stock Exchange, will that be an aggravating factor in their case? Because if it's not, there's a serious equal protection problem here. That this person is being somehow targeted with this aggravating factor.
So are you saying, normally when we talk about equal protection, we talk about invidious factors. Is there an invidious factor here? Is there any case law that supports that?
Yes, Your Honor. In my brief, I point out there's a case, I don't know if invidious is used, but it's an improper and irrelevant factor under the Smith case the 2006 Smith case that I cited. One of the factors that the court should not consider is an irrelevant or improper factor. And certainly what happens in 5,000 cases prior to us getting to our sentencing is an irrelevant factor. It's certainly a factor that we can't control. It's extrinsic to our case. It's nothing that I could have prepared for. So I'm not sure if that answers your question, but the ruling, the court made it clear that not only did it wasn't just taking into account the fact that my client was poor, it was based on a further derivative of other cases in which my client was being punished for the fact that other people have never paid restitution. And even in that argument the court uses as a basis, it mentions that even through supervised release, people aren't paying their restitution. But we haven't even been given even a chance to get that far, because the court's already determined that my client's not going to make this restitution, period. So even on supervised release, the court's, so we're going to punish him.
What if your client had plenty of do-re-mi and was well able to make restitution?
Well,
and nobody said a thing, okay. Then what?
Well, I think that we would have got a guideline range sentence.
So how do you get that across? You say to the judge, now judge, there's good news here, and that is my client is wealthy, he had a wealthy family, and he's going to be able to pay back.
Well, what I would say is that under 18 U.S.C. 3553A7, the need to provide restitution to any victims in this case is something the court needs to consider. And under that circumstance, if we have made whole a victim, that should be something the court should consider in its findings and basis of a sentence. So we would ask for a guideline range sentence in that situation. Now, that's what A7 says. It says the court shall consider the need to provide restitution to any victims. We tried to address that by bringing his wife down and explain to the court that we were going to make an effort through the whole family to provide restitution to the victim. But unfortunately, that was not considered. What was considered was the 5,000 cases where restitution was never made. And that was, and the court bluntly stated that, in part, it is basing its sentence on the fact that it didn't believe Mr. Navarro would be able to make that restitution. So I think that what we have here is that unless that the future banker, and in fact, the court addresses the future victims of our client potentially, but there are victims of fraud out there that have been devastated, and there are cases that are coming before these courts with devastating impacts, not only to individual victims, but to the communities as a whole. And this aggravating factor is not being used. They're getting guideline range sentences, albeit top of the range guideline. And even when the government in this particular case raised the issue that no restitution is ever paid, Mr. Gibson, the government, the prosecutor, was asked what the government's position was, and they still said, we need to promote the respect for the law and the other 3553 factors. But they still didn't ask for an upward departure. They said maybe upward variance, but something reasonable. Certainly 363% variance outside of the guideline range is beyond reasonable when we're talking about an aggravating factor that I still don't have any insight into how those cases would even compare to our case. So I can't even argue against that aggravating factor the court used.
Well, but as you know, under the Gall case and others, sentences above the guideline range can't be assumed to be unreasonable.
That's correct. And this was not a departure within the guideline range. It was a variance from the guideline range. So, we argued that. So really, the 3553 factors are even more important than the sentencing guidelines. Although the sentencing guideline in this case was 27 to 33 months, even if you take out the guidelines, this sentence under 18 U.S.C. 3553 creates an unjust sentence in that it's an unwarranted disparity between other fraud cases, other cases where there is restitution involved, based upon the aggravating factor outside of 18 U.S.C. 3553 A7 that it's simply not used correctly. Okay. How it's addressed.
I believe you've made all your points, and some of them more than once, which is fine. You're answering our questions. Is there anything else that you have to present on your opening argument, Mr. O'Shea?
No, Your Honor.
Okay, you've saved time for rebuttal. Thank you.
Thank you, Judge.
Mr. Ganjei? Thank you. No problem. I'm sure I've mispronounced your name, and if so, I hope you'll correct me.
It's Mr. Ganjei, Your Honor.
Ganjei? All right, Mr. Ganjei.
Good afternoon. Nicholas Ganjei on behalf of the United States. The matter before this court demonstrates that the cold record in some situations is inadequate for fully assessing the depth and breadth of the harm that a victim has suffered in a criminal case.
Now, as I understand it, appeal was waived in this case, right? But we're here anyway?
That is correct, Your Honor.
So how did that come about? Why does the government extract an appeal waiver and then not implement it?
Well, ultimately, that fault lies with me, Your Honor, and that is my mistake. But nevertheless, it doesn't change the merits and propriety of the district court's sentence in this case. So here, while we have the text and the calculations of the PSR, the district court's ability to hear from the victim himself allowed it to more fulsomely understand the devastation that it had wreaked. Specifically, Mr. Navarro-Jusino's criminal conduct had wreaked on his life, the financial predations that ultimately, in district court's words, destroyed his life. But almost as important as hearing from the victim, the district court was also able to hear directly from Mr. Navarro-Jusino and observe his prevarications between, on one hand, taking full responsibility for his criminal actions and wanting to make things right, and then in the next breath saying, well, we had a contract that allowed me to invest this money in a gym and other business projects. A representation to the district court that was actually refuted by the victim in court, saying that's absolutely not true. So after careful consideration of all the factors, the district court did not abuse its discretion in varying upwards. But more to Mr. Navarro-Jusino's argument that it was his ability to pay that was somehow determinative, there's several problems with that. The first is a matter of semantics. The fact that the district court was inclined, based on the harm to the victim, to vary upwards, and defendant was offering a justification as to why it should not do that, and the court ultimately found that unavailing, is not the same thing as varying upwards on the basis of Mr. Navarro-Jusino's inability to pay. Second, it sort of assumes that was the dispositive factor, that if he had the ability to pay, that it would have been a guideline sentence, and that's highly speculative, and the district court did a pretty thorough job of describing all the 3553 factors and the reasons for its upward variance. And third is that the district court was entirely justified in disbelieving Mr. Navarro-Jusino. Mr. Navarro-Jusino had been stealing from the victim from 2012 to February 18, and after he'd stolen every dime from the victim, moved to a car dealership and stole money from a victim there. And what was his answer when he was caught? He said, well, let me pay it back. Don't turn this over to the authorities. I'll make it right. So I think the district court, that among many other factors, had a very good reason to disbelieve Mr. Navarro-Jusino. And so not just the previous theft, but the instant offense conduct, which the district court said, why should I believe you given what you've done to the victim? His failure to be upfront with the United States probation by not providing any of his financial records as required. Dishonesty of the court in regard to this contract that he alleged allowed him to put this money in a gym instead of when he was actually just spending it on personal use. And ultimately that he failed to live up to his bankruptcy obligations where he agreed to make payments against his creditors, which he failed to do. So it was not simply that the district court was justified. It was probably actually very smart that the district court did not believe Mr. Navarro-Jusino's representations.
The government did not ask for an upward variance, is that right?
That is correct, Your Honor. Ultimately, the district court did say it was considering an upward variance, and it asked the United States its position on that, and the United States said it would be justified. So one thing that the United States would argue in terms of the mechanics of the district court's upward variance is that while there is a 2-point enhancement here for substantial harm to the victim, there are not gradations within 2B 1.1 B2A3 that would justify, or not justify, but rather explain how affected the victim was. So, for example, if Mr. Navarro-Jusino had stolen from a couple and one of the two spouses planned to stay home with the children, the other one planned to work, and now they both had to work, that would be substantial harm, or they couldn't help their child pay for college, that would be substantial harm. But on a whole nother level is what happened here, where he's 68 years old, he has to move to public housing, he can't visit friends, he can never eat out again, he buys everything from a thrift store, complete and total wipeout of all of his finances that he worked his entire life to build. So the fact that there aren't gradations there, like there are, say, in the drug context between a minor participant and a minimal participant, in those situations, I think the district court was evening that up by imposing a higher sentence. And this isn't.
I guess I know this is going over ground that we've already covered here, but I guess I just don't understand if the facts are that dire, and I agree the record seems to reflect that they are. I just don't understand the government not applying the appeal waiver, but once there's an appeal, you never ask for an upward variance, and the two things really don't jive. There's something here that we're not seeing about what was going on.
No, Your Honor. If I can explain it, I want to allay any concerns the court has. Trial counsel did not ask for an upward variance. District court said it was going to vary upward. The United States said that would be reasonable. I'm handling the appeal. I did not activate the appellate waiver before the filing of the United States' brief. It's the United States' position that probably at this point in time it is waived, but the district court can certainly affirm on whatever grounds it wishes. So please do not hold my conduct against trial counsel, who did an admirable and good job on this case. So in terms of the actual factors that the court stated, said that it was regarding the very first thing was victim impact, that the victim destroyed that the Navarro-Jusino destroyed the victim's life to protect society from Navarro-Jusino, to provide deterrence to future cases, and to promote respect for the law. And when Navarro-Jusino continued to prevaricate, he said, well, I think you're making excuses. You're not taking full responsibility. He asked the victim what the victim wanted. The victim said, I would want a sufficient sentence where I'd feel justified in the outcome. I don't expect to live to the point where I would receive any money back from Mr. Navarro-Jusino, and was so emotional that he couldn't continue in court. And that's something that I can't adequately convey, and none of us can probably adequately understand, but that the district court was in a unique position to understand at that time. So, and I think, lastly, one would look at the egregiousness of the defendant's conduct. This wasn't a matter of he had money in his hand, and he was using it to pay off, for shelter or for food or some other opportunistic crime. Rather, this was set out at the very beginning to be a scheme where there was no investment fund. It was simply his checking account, his business account, that he spent on football tickets, international travel, furniture, jewelry. So it would be hard to conceive of a more callous and scheme that one could impose on a victim than to take their entire life savings, completely wipe them out, spend it on frivolous matters, and then in court say, well, we kind of had an agreement that I could take these opportunities, these business opportunities that never existed. And I don't want to say lie to the court, but made representations to the court that were indeed not true. So based on all of these factors, based on the record, based on everything that the district court identified and the matters in the PSR, it was entirely not abuse of discretion for the district court to vary upward. So unless the panel has any additional questions, happy to see the rest of my time.
Thank you, Mr. Ganjei.
Thank you, Your Honor.
Mr. O'Shea, you've saved time for rebuttal. So Mr. Ganjei tells us that your client was refusing to provide financial records. Will you tell us what the record shows about that and what occurred or didn't occur?
Well, Your Honor, that was not an issue that came up at sentencing. It was not an issue that the government made the court aware of during sentencing. I didn't believe it was an issue. He certainly had his pre-sentence report. They didn't object to anything within the pre-sentence report.
Well, let me ask the question more precisely. We've just heard from opposing counsel that your client refused to provide his financial records. Did that happen or did that not happen?
I don't know. It's the first I've heard of it.
You don't know anything about any requested or demanded financial records that weren't produced?
The probation officer who prepared the pre-sentence report never brought it up to me. The government, Mr. Gibson, never brought it up to me. It wasn't brought up by the court, so it's the first I've heard of that.
Mr. Ganjei also referred to some kind of a scheme regarding an automobile dealership. What happened with that?
Well, I think what happened at the sentencing is Mr. Navarro was in a situation where the court was asking very direct questions, and when Mr. Navarro said, I made a mistake, I think the court seized on that to, say, well, you've done more than a mistake, and then it kind of went downhill from there. Putting a defendant with no for very little criminal history in front of a federal court, a federal judge at sentencing is very risky, and in this situation, I would say he didn't do a very good job in speaking for himself. But it was a devastating impact to the victim. There's no doubt about that, as most cases are when they deal with large sums of money and the courts are dealing with millions of dollars. But even after all that, the government didn't move for a variance upward. And if the court had given a variance upward and it was a reasonable variance, we wouldn't be here. But it was a variance above the guidelines, and I know they're only advisory since Gall, but they still exist. And for someone with a Category 1, I believe, or maybe 2, to get a 363% guideline range, I just don't see that even in million-dollar bank cases. There is the question mentioned by counsel here about respect for the law. That's one of the things that 3553 asks us to do. So as a federal defender, I'm put in a position when my next fraud case comes in and they say, should we make restitution? And the government says, it's not going to help you. And then the judge says, I don't believe they're going to do it because no one's ever done it. Well, I really don't know how to advise a person at that point, Your Honor. So it really begs the question of how much respect for the law does that entail? Does that bring forth when you can't even properly advise a client when there's restitution involved, and they want to make payments. That's all I have, Your Honor.
Thank you, Mr. O'Shea. Your case is under submission.